Hilchos Ishus Perek Shmoina Asar, Laws of Marriage, Chapter 18. Today, the Rambam continues to discuss the laws that are applicable after a marriage ends, after a husband dies and leaves a widow. Yesterday, we talked about the principles that govern how a widow goes about collecting the money owed to her in the ksuba. Today, the Rambam actually takes a step back and addresses the laws that govern the support that has to be granted from a husband's estate after he dies and leaves behind a widow. This is called the principle of almana nizonet. The widow is able to get fed by the heirs or the estate that the husband has left behind. And there's many, many details that go into this, and that's the subject of today's chapter. Says the Rambam halacha aleph almana nizones minichse yershin. A widow is fed from the property of the heirs, kol zman al menusa, as long as she is in a state of widowhood, ad shetitel ksubasa, until she takes the ksuba as explained in yesterday's and 2 days ago's chapter. Once the woman even asks for the ksuba money, the moment she demands that the money be paid to her of her ksuba in court, she no longer gets the right to be fed from the property of the heirs. But so long as she hasn't yet collected the ksuba and she's still living on her husband's property, she gets to be fed as well. All her support is taken care of. The same thing applies if she sold the rights to her ksuba, or she used it as collateral, or she turned her ksuba document into what's called an apoitiki. Apoitiki is an Aramaic word, which is a combination of three words together. Poi tehei koi, here you will stand. It's basically a way of telling a creditor that I want you to collect, if you need to collect my money from my property, you're going to collect it from this specific field. Apoitiki, as you can see in the Hebrew how it reflects. Poi tehei koi, this is where you'll stand, designated property from which to collect either a loan or any other type of monetary owing that a person has. So if she takes her ksuba document and turns it into an apoitiki for somebody else, which means she tells him, from this property, or using this ksuba rights, you will be able to collect your loan. Whether she had made this declaration in the face of an expert court or even outside of the court. Whether she made these moves during the lifetime of her husband or after his death, the fact that she has relinquished in some way the rights to her ksuba, either by selling it, by using it as collateral, or by designating it as the way to have a loan collected, forfeits her rights to the support from the heirs. But if she only sold part of the ksuba, part of it she retained, she still has the right to collect support so long as she hasn't collected the rest of the ketubah. The moment a widow is consecrated by another man, enters into a second marriage, even if she hasn't demanded her original ksuba from her first marriage, she loses the right to her support as well, because again, she goes into a new marriage, showing that she's already having another man taking care of her, so the original rights get forfeited. Says the Rambam halacha beis kashem shenizenes achar moisei min nechasav. The same way she gets fed, her food is taken care of after the husband's death from his property. Kach neisnin laksus uklei tashmish umoder shahoisa bechaye baila. They also have to supply her, the heirs, with clothing, with household goods, with a place to live, the same place that she had when she was in the life of her husband. She can use all the pillows and blankets and all the slaves and maidservants which she had used in the lifetime of her husband. If the living quarters where she was living in fell down, the heirs don't have the obligation to rebuild it. They have to let her stay, but not to make a new home. But if she says, even if she says, leave me alone, I will rebuild it for my own money, we don't listen to her. She has no rights for that. Neither can she do something to strengthen the build of the home, nor can she repaint it. Either she can live in it as is, or she has to leave. The heirs aren't required to raise the quality of her living state. If the heirs go ahead and sell the living quarters of a widow while she's still alive and supposed to be living there, their actions are of no consequence, it makes no difference. She has the right to live in that property. Gimel nafal habayis if the home fell down, in which case we don't listen to her to rebuild it, or to begin with, her husband never had an actual place of his own, he was only renting, the heirs are required to replace that with a new living quarter to match her social standing. The food that they give her, the clothing they supply her with, is all to be given according to her social standing. If her husband's social standing used to be higher than hers, we supply her with clothing and supplies according to his social standing, as we've seen before already in these laws. The woman always ascends in status to match her husband, and never goes down. Even after death, she retains that status that she had while she was married to him. Says the Rambam a very important rule about the type of support the woman receives. Birkas habayis meiruba. The blessing in a home gets bigger as the household members get bigger. It's a general principle. What does that mean? Ketzad. What does that look like? It's a basic principle. You have 5 people. Each one, had they been eating their meal on their own, could consume the amount of a kav, a certain measurement. Typically what happens is if you put 5 people in a room together and have them eat together from one dish, maspik lahen arba kavin. Even if individually they can each consume a kav, now for this more public dinner, all you'll have to have is just 4 kav. Because the blessing gets bigger as the household gets bigger. That's the principle. The same rule applies for any other needs of the home. When more people live together, you end up spending less. You end up using less. Lefichach, therefore, as it relates to our topic, almana she'amra, if a widow says, listen, eineni zaza mi beis avi, I was married to the husband, to your father. I'm leaving. I'm going back to my father's house. But I still want support. Piskuli mezainis utnuli sham. Set me a fixed amount for my support and bring it to me in my father's home. Says the Rambam, the children can say, the heirs can tell her, if you live in our home, we'll give you food. Ivim lav, but if not, we're only going to give you proportional to the amount that would have been consumed if you would have been an additional member in our household. In other words, now let's say there's 6 children, and she would be the 7th one. They would end up spending far less than if they would feed 7 individual meals. She's asking for individual meals at her father's home. They can say, either you come to us and get food, or if you choose to stay in your father's home, we're only going to give you proportional to what 1/7 of a bigger household would consume. But if she had a reason for her claim, she's not just saying, I want to go to my father's house. There's a reason why she's saying that. She explains, she's younger, they're also younger, it's immodest. Then, that's a justified claim. And the children have to supply her with food, enough for her, on her own, while she's in her father's house. If there's anything left over from the funds, which the heirs put aside to feed the widow or to give her clothing, those extra funds return back to the heirs. It's their responsibility to feed her. They get the benefits of getting all the extra money back. Another related benefit that a widow has. Almana shecholsa, if a widow gets sick, if she requires medical treatment that cannot be defined in advance, it's going to get bigger as the bills go on, time goes on, she may need more and more treatments. We treat that medical treatment like food. And the heirs are required to supply it. However, if the treatment, it's kind of counterintuitive, if the treatment that she requires can be defined, we know we're only going to have to spend $1,000, and that's going to cure her of her ailment. That becomes a personal liability that she has to carry, and she can only heal herself using the funds that she's received from her ksuba money. Nishbeis, if a widow is taken captive, ein hayershin chayavin lifdaisa. The heirs are not obligated to redeem her. A husband is obligated, as we've seen before. It's one of the 10 things he commits himself within the framework of a marriage. But heirs are not. Afilu haisa yavama. Even if she was waiting in the wings for levirate marriage, that means her husband died childless, and she's waiting for the husband's brother to marry her. So technically, in some way, she's still connected to this family. Or even if more so, she was taken captive while her husband was alive, and at that point, the obligation did rest on the husband to redeem her. Then the husband dies, the husband dies while she's in captivity. That obligation does not transfer to his estate or to his dead brother, or to his alive brother, Neither of them have to redeem this widow. Either she can redeem herself using her own funds, or she can take the money allotted to her in her kesuba and use that to redeem her, but no other parts of the husband's estate should be used or need to be used towards her redemption. If a widow dies, the heirs of the husband are obligated to bury her. The same way that the husband in his lifetime was obligated to bury her, that obligation does devolve onto his heirs, and they have to take care of her burial issues. But if she had already taken the oath of the widow, we saw about that yesterday and 2 days ago, before a widow collects her kesubah, the court administers an oath to make sure she didn't misuse any of the husband's estate. That's the beginning of the process of collecting her kesubah. So if the widow had already had enough time to take that oath, and only afterwards did she die, since by taking that oath she already separated herself from her husband's estate because she's declaring, now I want to collect my kesubah and go live on my own, the obligation for her husband and therefore his heirs to bury her goes away. Her heirs, any relatives that she has on her side of the family, get the rights to collect the ksuba, which she initiated the process of that, and they therefore have to take care of her burial. No longer the heirs of the husband no longer have to take care of that. Any handiwork that produces money made by the widow, layershin, goes back to the heirs. They're taking care of her food, they get her handiwork, just like in the lifetime of the husband. That was one of the exchanges. The husband provides food, she provides her handiwork. Since the heirs are providing food, she provides them with her handiwork. If an heir told the widow, listen, I don't want to feed you, you take your own handiwork, whatever money you can produce with your hands, and keep that as your food, we do not listen to him. But if she wants that deal, we listen to her. This is exactly the same way as it was in a marriage. A woman can say, I'm confident that I'm going to produce enough to take care of my food. Therefore, she can tell the husband, I don't need your money, I'll take care of myself. But the husband can't go backwards and tell it to the wife, because maybe the woman won't produce enough, and the husband won't be living up to his obligations. Therefore, when he dies, the heirs have the same law. She can give that offer, but they cannot. Any work that specifically a wife would do for a husband, a widow must do for the heirs that are allowing her to live on the estate. With the exception of 3 things that are much more intimate and private, and a woman would typically do only for her husband: diluting his cup of wine before dinner, making his bed, and washing his face, hands, and feet. Any objects that are found by a widow, as well as any fruit of properties which she brought into the marriage, la'atzma, go back to her, and the heir does not have any rights to them. Let's just quickly remind ourselves about this concept of the nedunya. The woman, any property she brings into a marriage is called under the general umbrella of nedunya. Those then divide into 2 categories: nichsei tzoin barzel and nichsei meloik. Guaranteed property and usufruct property. Guaranteed property means the husband takes the property, it becomes literally his. All he has to do is replace that value. But any losses or benefits that accrue to the property accrue to him. The other category is usufruct property. The woman retains ownership of the actual property. The husband in his lifetime could only take the fruit that grow out of that property. So first the Rambam addresses those fruit. Those fruit, which were part of the husband's rights, now transfer back to the woman. What about the properties themselves? The properties themselves, which were the nedunya, the stuff she brought into the marriage. So, if we're talking about the nichsei maloi, the usufruct properties, she takes them right back with no oath. They were always hers. The heirs have no judicial rights over them. Only in the case of the guaranteed properties. If there was a profit that accrued to those properties, which really during the time of the marriage, who would get that profit would be the husband. That's the only that increment, only that appreciation in value are what the heirs are able to claim in court. And therefore, if the widow dies without taking an oath to the heirs who have a claim on that appreciation, she dies without taking an oath, her heirs can take back the property, even if it's a guaranteed property, because the husband only has the rights to the appreciation. If there's an appreciation, that appreciation goes to the heirs of the husband, but they can claim nothing more than that. The property itself goes back to the wife, and if she dies, it goes to her heirs. Halacha Yud. Till now we're talking about land issues. What if a widow sees that her husband is dead? She knows she's going to have support. She goes into his house and grabs a movable object, which she's going to use now to create support for herself. Whether in fact she actually grabs this property while he's still alive, or after his death. Afilu tafsa kikar zav, even if she grabs a talent of gold, much more than what she's going to need, at least in the short term, ein moitzin miyada, we cannot take it out of her hands, because technically she has a right to it, and if she takes it, that becomes her source of support. How do we manage it? The court writes down a written record of what she has taken, and they allot a certain amount of funds that she needs for support for the short term, and they then calculate with her against that movable property which she has extracted, and she keeps on getting fed from whatever property she has in her hand, either until she dies, or until she enters a state where she no longer has the right to get food. For example, she goes into another marriage. At that point, the heirs then take whatever remains of that, let's say that talent of gold, which she didn't use up everything, they take it back because it's no longer being used in support of the widow. Similarly, if she grabbed hold of some movable property in replacement of her ksuba, not a replacement of food, her ksuba money which she's owed, the 200/100 or the extra committed money, she grabs onto a watch or a Lamborghini in place of that while her husband is alive, umeis, and then he dies, goiva mehen, she can actually collect her ksuba from those properties. But if she grabbed hold of movable property after he dies, for her ksuba, eina goiva mehen, she cannot take the money from there. As the commentaries explain, this only applies in earlier times when, as we saw the other day, only land was to be used in collection of a woman's ksuba property. However, the Rambam continues, and here begins halacha yud beis according to the real authentic manuscripts. Tiknu hagaonim, the gaonim made a takana, an enactment after the Talmudic era, shatig behaksuba utnoi ksuba min hamitaltalin, that a woman can collect her ksuba money and she can collect any other ksuba related rights from movable property. Lefichach, therefore, nowadays post the gaonic era, when this enactment went into effect, a woman can directly receive her funds for support from movable property, even if she doesn't grab it. Simply the court in allocation can do so from movable property because it's rightfully hers. However, if the husband left over movable property and she did not yet grab hold of them, the heirs should then take them, and they from there will allocate funds to her for support. She cannot stop them and say, since I'm getting fed from these properties, let these movable properties be put into escrow, into the hands of the court, and they will deal with it till I finish getting my food from there. If I leave it in your hands, maybe they're going to get lost and I'll have no food. We don't listen to her. That the heirs can keep it and they give the funds for support. Even if the woman during the marriage clearly made a stipulation that when the time comes she's going to get her support allocated from these specific movable properties, she still holds no sway. She cannot hold the heirs back from taking the properties and them allocating the funds. And this is how indeed we adjudicate the laws in all of our high courts in the area that I know, says the Rambam. If the husband left over land and the collection is taking place from this land, then the woman can stop the heirs from selling it and say, I want to get my support from that land, you cannot sell it off. The imachru, if they didn't listen to her and they sold it. Unlike usually when there's a lien, you can go after the buyer and expropriate the property. Here she cannot expropriate this property once it was sold. Because the wife who gets her support from the husband's estate, and also the daughters, as we're going to learn, that they also get money from the husband's estate, from their father's estate, they can only get fed from what's called free property that remains in the husband's estate. Once it was sold, they have no claim to the properties. Halacha Yudalid, a man left many wives after he passed away. Even if he married them one after another. Unlike when it came to yesterday with collecting the ksuba, whoever gets married first gets the ksuba money first. When it comes to support, they get supported from the husband's estate equally. Because there is no right of precedence when it comes to food and support allocations. Halacha Tezvav, almana shenafla lifnei yavam. If a widow, her husband dies, but now she's also fallen to a yavam, to yibum, to levirate marriage. The husband died childless. She's in the wings. She has to get married to the dead husband's brother. The rule is, as we're going to learn later on in this book, that levirate marriage cannot take place right away. Because the whole idea of yibum is assuming that the woman is childless. But during the first 3 months after the husband's death, it could be that she's pregnant and we just don't know about it. So the sages never let yibum take place within the first 3 months after death. Therefore, says the Rambam, if there's a widow who's waiting for yibum, bishloisha chadashim harishaynim nizenes mishel baal. In the first 3 months after the dead husband has passed away, she continues to take food from his estate because she's still down to him. She cannot get married to the new husband. And if in that time the fetus begins to show, it turns out that she's pregnant, or if the husband to begin with left her pregnant, she continues to get fed from the husband's estate until she gives birth. Yolda ben shel kayama, if she gives birth to a viable child, now she's treated like any other woman, and she can take food all the days of her widowhood from the husband's estate. But if it turned out she wasn't pregnant after those 3 months, or she miscarried, it was a non-viable child, in which case she reverts back to the state of being childless and has to go through with the yibum. At this point, she's neither here nor there. She can no longer collect food from the husband's estate because now she has to get married to the new guy. But because she hasn't gotten married to the new guy, he doesn't have to give her food yet. All she can do is demand that her new husband either bring her into a marriage or do chalitza and free her to go live on her own. If she did file that suit, she tells the new husband, you have to marry me or give me chalitza. And he comes to court. And then he ran away, or he got sick, or to begin with, he was out of town, and she couldn't bring him to court. At this point, the responsibility moves on to the yavam, to the new husband, and she can take money from his estate for food without any oaths at all. Because she did her best. She filed the suit, she brought him to court. He escaped, that's his fault. An unfortunate case, if a woman falls to yibum, to a man or to a boy who is a minor, her husband died childless, and the only brother he has alive is 10 years old. And she has to wait now till he's old enough to do either yibum or chalitza. She gets no food, she has no right to support from his estate till he reaches majority and becomes like any other yavam. The Talmud says this is actually an unfortunate case. Kansuha min hashamayim. It seems like they find her from heaven. There's no reason why she shouldn't get support. She's a regular widow. Just because she's waiting for a young boy to grow up, you would think she should get some food. No, Hashem put her into this case. That's Hashem's way of saying, I'm sorry, no food for you from these estates. Go take care of yourself. Yud Ches. Misha yiched karka le'ishtei b'mzeineseha b'shas misa. A person, while he's on his deathbed, designates a piece of land for his wife's support. The Omar, and he says, Yiyeh makom pleini lamezainis. That field, that place, is going to be the source of supplying my wife's support. Harei riba lamezainis. By making that statement, he only works to her benefit. He has added to her support. What do I mean by that? If the money to be made from that piece of allocated land is less than what she requires for food, she gets to take the rest of what she needs from any of the other estate. The fact that he designated it only works in her favor, not to her detriment. If indeed it works in her favor and the money she can make from that land is more than what she needs, she takes everything. Because the husband said that's for support. But if he said, not that the place will be for her support, let it be in that place for her support, Vishaska, and she's quiet, she knowingly agrees to that agreement, then indeed she only gets the fruit that grows from that spot, because with that expression, the little difference in language, he has decided that that's going to be the only source of her support, and therefore she could have protested. If she didn't, she remained silent. She's agreed, and that's all she gets. A woman comes to court. Till now we're talking about the default laws, how the heirs should be acting with her and taking care of a widow. What if the widow, husband passes away, she needs support, she comes to court, and she's asking them to help take care of her funds for support. Yesh mi shahira, says the Rambam, there are those that have ruled. So the court can take matters into their own hands, allocate funds for her support without requiring her to take an oath. Unlike, let's say, when it comes to the Kesuba collection, she must first take an oath that she didn't misuse the husband's estate. Here she needs no oath. It says the Rambam, I disagree with that. It's not proper to rely on this ruling. Whoever made this ruling got confused between this case and a case of a woman whose husband travels on a journey. In that case, as we saw in chapter 12, when a husband travels away and now his wife's food is not being taken care of, she must, if she goes to court, first take an oath. She must not take an oath over there. It's the husband's rights, he's alive. Here, when the husband dies, no. She has to take an oath. As the Rambam says, my teachers have ruled, she gets no support from the court till she swears. Because by taking funds for support, she is in effect taking away money from the heirs. When we have an ironclad rule in halacha, whenever anybody, be it a wife, be it a creditor, whoever it is coming to take money from property that belongs to an heir, to an orphan, only can take their collection with an oath. This is the way my mind turns as well. I believe in this opinion, says the Rambam. This is how it's proper to adjudicate matters that are related to this, and therefore the Rambam will describe the following cases from that context. If a widow comes to court to collect food, first thing we do is we make her take an oath, as we just said, and then we can sell any properties from the husband's estate without announcing it. In other words, we just go right to it, get her food as fast as possible. Announcing it would give her a better price, technically, potentially. But we just do it right away, we intervene, sell the property, and supply her with food. Also, the truth is, she can go ahead and sell on her own property of her husband's estate without using an expert court for food. She finds 3 trustworthy people who are expert in appraising land. No need to announce it. Make the sale and she can take care of herself with food. Similarly, if she sold on her own, no appraisal, no 3 people, on her own, but she sold it at a good market value, the sale is valid. If at any future point the heirs want her to take an oath, she'll take an oath. All these rules mirror exactly what we learned yesterday when it came for the ksuba. A woman can make her own sale of the property outside of the court if she has 3 trustworthy people. On her own, she could also take it into her own hands, assuming she makes a market value sale. But be that as it may, the court will sell property to feed her after her husband's death. But there's a process. How much do we sell at a time for food? What do we go sell? If husband has a hotel, we sell the whole hotel. Now we have millions of dollars for food. That makes no sense. It says the Rambam, we sell enough to provide food for 6 months. No more than that. No less, because then you won't get a good price. But no more either. Half a year at a time. Even that, while we make the sale, there's a condition that the buyer only has to supply the woman with food once a month. So he bought enough to feed her for 6 months. Every 30 days, he gives her a check. After 6 months, sell it again for another 6 months. Some more of the property. And so she keeps on selling and going. Every 6 months, she comes to court. It sells some more for another half a year. Either until, of course, she enters another marriage or whatever it is, or until there's left over in the property only the amount which covers her ksuba. At that point, let her take her ksuba from whatever is left and then leave. The commentators explain this is just sound financial advice for the woman. If she keeps on collecting food, she'll have to only go in increments of 6 months. If she sees that all that's left is $200 and that's what she's owed in the ksuba you can collect all at once as a lump sum. So better just go to court, get the whole ksuba, and you're good. And then because there's no more property in her husband's estate, she has no more demands on him, and therefore she just goes and her deal is over. If a woman had funds allocated to her by the court for food, we don't ask her to comparatively evaluate how much money she's making from her own handiwork. The court doesn't step in and do that. The heirs can come and do that. If they say, look, the court's giving you money for food, any money you made from your handiwork should go to us, they can ask her for that back. If they find that she indeed produced stuff, they can take it. If not, they go on their way. Says the Rambam, I say, that if the heirs were minors, the court will step in and make the claim for them, and they will allocate the funds related to her handiwork to go back to the heirs, the same way they're allocating funds to go to her for support. If a widow cannot produce a ksuba document, she gets none of the above. The whole first 22 laws of this chapter don't apply if she cannot prove that she was married. She can't show the marriage document. Because maybe she pardoned the ksuba, or she sold it, or she used it as collateral. We saw in halacha number 1 of today's chapter that the minute she relinquishes her ksuba, she has no more food. So if she can't show the document, maybe she did one of those things. Even if the heir doesn't make that claim against her, it's one of the few cases where the court steps in and we make the claim for the heir, and we say, first bring your ksuba, then make the oath, then take your food. Unless, of course, it's those locales where they don't write a ksuba at all, then she doesn't have to use it to prove it. But if they do, she has to produce her ksuba. A woman goes on a trip, on vacation with her husband abroad. She comes back and she says, Meis Bali, my husband has died. We saw 2 days ago, she's believed. A woman can say that, my husband has died, and we allow her to marry. At this point, since we believe her that her husband died, she can take the next step that any widow would take. If she wants, she can get food allocated from her husband's estate. If she wants, she can just get her ksuba money allocated to her and leave. But if she comes back and says, Gershani Baili, we had a massive fight on vacation, my husband divorced me, she's not believed. However, even though she isn't believed as to her marital status, she could keep on taking money for food from his estate so long as it reaches up to the amount of her ksuba rights. Because that's hers either way. Assuming she's still his wife, he must supply her with food. Even if it's true what she's saying, that she's divorced, she gets the right to her ksuba money, she's holding the document. Therefore, so she can take food up to the amount of the worth of her ksuba document, and then she leaves, and she's done. A woman who was in a doubtful divorce. We'll see in the next set of laws many different ways that a doubtful divorce can be created. It wasn't handed over the right way, it wasn't written over the right way, a whole bunch of cases. So she's in a state where she's doubtfully divorced, then her husband dies. Now she's for sure a widow. At this point, she can no longer declare the rights to food for support from her husband's estate. We cannot expropriate money from the heir out of doubt. Maybe she's divorced. If she's divorced, she's forfeited all her rights to food. So therefore, she doesn't get any food after he dies. While the husband is alive, a woman who's in a doubtful divorce still can claim the rights to food until she gets a complete, valid divorce. A poor widow who waited 2 years and didn't ask for food, or a rich widow who waited 3 years and didn't ask for food, Vitra has forfeited her rights, and she cannot retroactively claim the food that she was owed for the past 2-3 years. Going forward, she could. From the moment she asks for food, she will get the food. But for the past, she cannot collect. But if she waited even 1 day less than that, she asked for food the day before 2-3 years were up, loy vitra, she hasn't forfeited anything, she can demand and take all the food that has accrued over the last 2 years. A widow demands food from her heirs. They say, we gave it to you. She says, no, I never got it. As long as she hasn't yet remarried, the orphans have to bring the proof. The burden of proof is on them. Or she takes a rabbinic oath and takes the money. Once she's gotten married, she has to bring the proof. The burden of proof is on her. Or the orphans can take a rabbinic oath that they already gave the money and they're exempt. The Rambam concludes with a general principle that applies to everything we're talking about. Din taisvis ksuba kedina ikar. The woman gets promised in her ksuba a base amount of money, 200, 100, depending on if she's a virgin or not. She also gets promised a tosefet, an additional amount that each husband commits to pay to his wife. Halachically, the rules governing the addition are the same as the rules governing the mainstay. Lefichach, therefore, going back to the first halacha in this chapter, almana shetava, oy machra, oy machala, oy mishkana, tosefes ksubasa ima ikar. If the widow either demands payment of, sells, pardons, or gives as collateral the additional part of the ksuba money that she's owed with the mainstay, ein la mezainis, she's forfeited her rights to food. V'im tava miktsas, v'hinicha miktsas, but if she only demanded part and left part, even if that part is only a part of the additional payment, it's still considered to be leaving part of the ksuba for her own. She still retains the rights to her ksuba. Harezo kimisha tava miktsas ha'ikar, v'hinicha miktsasa. It's like giving away part of the mainstay and asking for part of it. And therefore it's fine, she still retains the right, she can still get food. However, know this, when a woman sells her ksuba or pardons her ksuba with no stipulation, she just says, I'm selling you my ksuba, that includes the entire umbrella. She has sold or pardoned the addition together with the mainstay. Because both together are collectively titled ksuba in every place in halacha. And so when she says that, I'm selling you my ksuba, she has sold everything and thereby, in this case, as it relates to us, has relinquished her rights for future food for support.